In the sizzling world of trademarks, selecting the perfect brand name is akin to concocting a tantalizing recipe for success. Picture yourself embarking on a culinary adventure, envisioning a restaurant that will provoke taste buds and leave patrons clamoring for more. It's natural or almost a knee-jerk action to gravitate towards names like tasty or delicious, as they effortlessly convey the mouth-watering allure of your culinary creations. However, as many others would like to adopt tasty, whether for trademark purposes or simply to describe their culinary offerings, descriptive marks are typically disallowed. This is, however, not always straightforward to determine whether a trademark is descriptive or not. A landmark case from Hong Kong provides a fascinating glimpse into the realm of trademark law. Though it occurred over a decade ago, its significance remains undiminished, standing as one of the most influential decisions in Hong Kong's legal history. Yet this video won't go into the details of the case's journey all the way from the Trademarks Registry appeal to the Court of Appeal. Instead, our focus lies on the trademark itself, highlighting its playful nature and shedding light on the nuances of trademark laws. This is a story about Condom. Yes, you heard it right. We assume that many of our dear audience have had experience using condoms. What brands stand out to you as the best in your experience? Why do you prefer these brands? Please share your honest thoughts with us. Now consider one brand that likely catch your eyes. Naked. Quite cool, isn't it? But let's pause here and ponder. When applied to condoms, does it merely describe the state of undress, or does it whisper secrets of sensuality and intimacy? The examiners at the Hong Kong Registry issued official objections against the naked application. Well, if you're fond of the name naked, the registry's objections may not be entirely unwarranted. After all, the sensation of feeling naked while wearing a condom is arguably one of its most desirable features. Refusing to accept the registry's stance, the applicant fervently contested the decision and escalated the matter to the High Court of Hong Kong, determined to prove the distinctiveness of the naked brand. Guess what? The court sided with the applicant, marking a triumph for the naked brand. Applying the case laws, the court introduced the concept of a sliding scale, offering a practical approach to trademark evaluation. At one end lies descriptors, warranting refusal of registration, while at the other end sit suggestive marks, eligible for registration. This added complexity to the evaluation process, highlighting the importance of assessing how easily customers can grasp the meaning behind a mark, that is, the mental steps gone through by the customers in this decoding exercise. In this scenario, firstly, we must grasp the essence of naked, and secondly, acknowledge the paradox that arises when considering the usage of the term in conjunction with condoms. Although wearing a condom technically negates the state of being naked, after all, the question arises whether it is a conventional practice to associate naked with condom usage or its inherent characteristics. Thirdly, despite the inherent contradiction, the evocative sensation of nakedness when using the product leads us to associate naked with the distinctive attributes of the condom, thus enhancing the customer's affinity towards the brand. As the court proceedings unfolded, the judge's eloquence shone through, adding a new layer of depth to the case. In a compelling articulation, the judge said, "One might imagine that two persons who wish to engage in safe sexual intercourse would desire to have as much intimate physical contact with each other, while nonetheless protecting themselves by using a prophylactic device." He went on to illustrate the paradox of the term naked in connection with condoms. He mentioned, the less obtrusive the condom as a result of its attributes including sheerness, color, weight, and comfort, the more exposed and uncovered each person would feel before the other. In this context, the desirable attributes of a condom could suggest nakedness, while the state of nakedness could hint at attributes desirable in a condom. The judge, however, concluded with a thought-provoking statement. He said, "One would need something of the mind of a puzzle enthusiast or, possibly, a poet, to perceive the relationship between nakedness and the characteristics of a condom." This statement highlighted the creative and interpretive nature of the trademark evaluation process. It showcased the importance of understanding the mental steps a consumer takes in associating a brand name with its product, thereby adding another dimension to the trademark law discourse. The decision on naked trademark application was later reversed in the Court of Appeal. Although the technical reasons for this reversal are not our focus in this video, it prompts us to delve into a more philosophical debate. As we dissect the nuances of trademark law, we find ourselves advocating for a more lenient approach towards play-of-words trademarks. These marks are often infused with a remarkable degree of creativity and wit, bringing a touch of charm to the marketplace. By embracing such inventive trademarks, we believe the Trademarks Registry can foster a more vibrant and dynamic business environment. But what about the third parties, you may ask? We argue that endorsing such trademarks does not unfairly disadvantage them. Instead, it encourages healthy competition and promotes innovation within industries. In essence, it's about celebrating creativity rather than stifling it. By recognizing the imaginative efforts of entrepreneurs and businesses, trademark authorities can act as champions of creativity. They can pave the way for unconventional, yet captivating trademarks to flourish, trademarks that inject excitement and intrigue into the world of commerce. These bold and inventive trademarks have the power to capture the imagination of consumers and set brands apart in a crowded marketplace. So let's raise a toast to creativity in the trademark world, and let's hope for more naked surprises in the future. As we wrap up our exploration of the naked saga, let's turn our attention to the implications for you. If you're an entrepreneur or a business owner, the choice of a trademark isn't merely about branding but also about navigating legal complexities. If you prefer to avoid the hassle of lengthy disputes with the registrar and want to save both time and costs, it's advisable to opt for a simple and non-descriptive mark. For instance, choosing a mark like XDX for your restaurant services is less likely to draw official objections or opposition from third parties. However, if you're determined to secure playful and imaginative trademarks, remember that the road ahead might be filled with challenges. In such cases, it's essential to enlist the expertise of professional agents like Origin and many other local agents at Trasomark. They can craft compelling rebuttals on your behalf, providing a strategic approach that could yield significantly different outcomes. With their expertise, you can potentially secure approval for your desired trademark, even if it's as audacious as naked. As we close this chapter on the saga of naked, we eagerly anticipate your next creation. You're not just an entrepreneur, you're a creator. Brand boldly, and remember, it's about making your mark. We can't to see what you'll create next.